Welcome, everyone. This is going to be a live stream of Measure 114, Part 2, on December 23rd, 2022. And so I will have my personal audio muted so that we can hear what's going on in the courts. Sorry, I forgot to mute my cell phone. So I'll be live in the chat during the court hearing, but I will not be talking over the courts. We will come back and discuss everything during recesses and during the lunch break, and then we'll probably stay live a little bit after the court hearing is over, and we shall discuss everything then. So I want to thank MC for being first in, G-Webs, CB, fellow Oregonian, Miss She Fires is out there. I'm going to play my intro.
In a world of uncertainty and turmoil, one man stands alone, along with his faithful sidekick. A man who entertains and educates the masses weekly, 70% of the time. Born out of the dusty plains of Washington State, now from the coastal forests of Oregon. The man, the myth, the man, G23.
So we want to thank everybody. We've got GGW Outdoors out there, and we got another guy, Dumb Jet, out there. So welcome, everyone, and hopefully we'll get the court started. Normally they'll start it's scheduled for 10. Now they may start a few minutes early, or they might be a few minutes late, depending on what's on the docket beforehand. So with why I decided that I would schedule this to go live a few minutes before, so we could get all the talking and everything done pre-show, pre-hearing. This way we're not talking over the top. There are links out there for people if they want to join and listen in. And again, we'll talk during court recesses and after the fact. So we've got Lowballin' Outdoors out there. Welcome. And so I'm hosting this not only so that everyone can see what's going on here in Oregon, but again, we have these court cases going on, but we have other politicians in other states that are, trying to see what they can get away with. So this is also, to help you guys in other states have good arguments on, hey, the stuff's not going to fly, and here's the reasons why, And then if it, by chance, you guys have to take it to court in another state, like Maryland, California, Washington, New Jersey, you guys got great arguments. So you can see what works and what's not working, and then figure out how to tweak what didn't work to make it so that you have better arguments and make stuff work. So it's one of the reasons why I host these. And
is that live too?
Okay, I will be shutting up because the courts are starting.
I really hope my parents are logged on.
So FYI, Smeggy G-Webs, there is a link over in Gilded.
Yeah. No, that's fine. That's fine. Just in case I run out. How much water I drink depends on how nervous I am. So if this is, I guess how much I talk to.
I apologize. I forgot to introduce myself. I'm going to go. My name is Rick Harrington. Yeah. So when you hear from me, you'll know. All right. Good morning, everybody. Thanks again for coming. I think everybody's about in here. We're going to start pretty quick. I just kind of wanted to go over again, just a reminder, no weapons in the courtrooms, no hats while court is in session, to include glasses on the head, please. No recording devices or photos, and no emotional outbursts that would disrupt the proceedings. Thank you.
Please rise. Circuit Court is now in session. Honorable Robert S. Raschio presiding.
Thank you. You can be seated. We're going to go on the record now in Joseph Arnold, Cliff Asmussen, Gun Owners of America Incorporated, and the Gun Owners Foundation versus Kate Brown, Ellen Rosenblum, Terry Davey, Harney County case 22 CV 41008. The plaintiffs are represented by Tyler Smith and Tony Aiello, who's present in the courtroom. I have Harry Wilson, Special Assistant Attorney General, and Senior Attorney General Brian Marshall for the defendants. This is the time set for further proceedings regarding what has been referred to as the Charleston loophole, and we're going to proceed with a determination as to whether the court should lift its temporary restraining order on that if the court determines that it is separate and distinct from the permit to purchase portion of the ballot measure 114. I think that's the framework, is it not, Mr. Aiello?
Yes, Your Honor. Plaintiff's understanding was that this would not be an evidentiary hearing where we look at the Elkhorn factors, but we do have witnesses available, and we've prepared our argument as to the merits if that's what the court is intending to hear today.
Yeah, okay. Mr. Wilson, are you arguing this, or is Mr. Marshall? I should have asked.
I will be arguing this, Your Honor. And as a preliminary matter, Your Honor, we did reach out to plaintiffs yesterday to ask if they had any objection to a court reporter being present on the public line. They had no objection.
Motion.
Very good. Thank you, Your Honor.
Okay. Well, I guess preliminarily I'll say that I think the question that is most pressing to me is the questions raised in B and C of the plaintiff's response. That I think is the most interesting question to the court for purposes of today's hearing. The effectiveness of, I guess the administration of background checks to me strikes at a different issue that exists outside of the question of whether ballot measure 114 is constitutional on its face or not. The reason being that I think that there have been, the court clearly from the pleadings, background checks have been a part of Oregon's statutory scheme for a very long time. If the executive branch is slow walking those, if they aren't promptly, instantly taking care of background checks, that's a separate litigation that doesn't deal with whether they're constitutional on their face or not. Would you agree with that, Mr. Aiello?
No, Your Honor, because the issue that plaintiffs have raised is that the state has, if these provisions of ballot measure 114 are allowed to go into effect, the state has no requirement to process the background checks timely. Before, in the pre-measure 114, there was a relief valve. There was the ability for a firearm dealer to transfer the firearm without a completed background check. That made it not an issue of whether the state was slow walking it, but an Oregonian was free to shop where they would like to seek out a firearm, one of those few firearm dealers who would transfer the firearm without a completed background check. So there was no issue between Oregonians and the state. It was between Oregonians and the firearm dealer. Now, with the closure of that relief valve, now the state is infringing or will be infringing on the rights of Oregonians, because Oregonians have no guarantee whatsoever that their background checks will be timely processed, despite the requirement in the statute that the background checks are processed immediately. The evidence before this court, the written evidence, let alone the testimony that we would bring in, demonstrates that broad discretion is in and of itself violative of Article 1, Section 27.
Mr. Wilson, your response?
We agree, the defendants agree with Your Honor that it would be a separate litigation to consider whether the background check amendments as applied prejudice any particular plaintiff. We disagree that plaintiffs have alleged any claim, facial or as applied, against the background check amendments. If you refer to the specific allegations within plaintiff's claim in their complaint, they all, by their express wording, apply only to the permit provisions or to the large capacity magazine provisions. There has been no allegation that a particular plaintiff has been unable to obtain a firearm because the background check amendments have delayed the process so long that he or she is unable to acquire a firearm. And there's been no allegations that the background check amendments standing alone are facially unconstitutional under the Oregon Constitution. So we believe it needs to be properly alleged and brought before this court, and it isn't at the present time. And therefore, there is nothing for the court to consider with respect to the background check amendments here today. The TRO should be dissolved as to them.
That's one issue, not the entirety of what's been alleged. All right. I'm going to make a decision based on that information. I'm not taking any other evidence on the slow. I've reviewed the pleadings from both sides, including their affidavits, their declarations about how slow the background check process has been of late, which is countered by the state in terms of saying, well, we had 85,000 independent background checks to do after the passage of 114. All of that I'll consider, but I'm really most interested in focusing in on the severability question, which I think raises different construction problems for the defendants.
Your Honor, if I may, just one more thing here. To the extent that Your Honor determines that the allegations were not properly raised in the complaint pursuant to ORCP 23, plaintiffs would ask that the court allow the pleadings to be amended to conform to the evidence.
Yeah, that's not it. That's not the issue. I mean, the issue for the court is this. I mean, if in fact the state were to, at any time, the executive branch were to slow walk background checks to a degree that's demonstrable, there's a separate, distinct action. Doesn't have anything to do with what we're doing here today.
Thank you, Your Honor.
So go ahead in terms of your arguments on the severability question.
Thank you, Your Honor. At the outset, plaintiffs would like to state for the record that characterizing these provisions as a loophole is disingenuous and incorrect. The ability for a firearm dealer to release a firearm without a completed background check is not a loophole. It is a designed function of both the pre-existing ORS 166.412 as well as the Brady Bill federally. These provisions were designed to protect firearm owners from unfettered discretion on behalf of ICS and FICS. The court should decline to lift the TRO with regard to these provisions for three reasons. First, defendants argue that neither plaintiff's complaint nor motion address the completed background check requirement, and defendants are incorrect on that, and the written materials we submitted demonstrate that. Second, plaintiffs contend that for defendants to enforce this requirement separately from the permit to purchase scheme would require this court to either sever the provisions, which is inappropriate at this juncture, because severability cannot be determined before constitutionality is determined.
My understanding is you're saying that the constitutional question on the permit to purchase is intertwined to such a degree with this portion of the law that that the court should not sever out this portion without making a full determination on whether the entire permit to purchase program is constitutional or not.
Yes, Your Honor. As in addition to that, Bernstein Brothers, a case cited. Okay, perfect. Third, plaintiffs contend that for this court to allow defendants to enforce the completed background check provision, the court would have to rewrite ballot measure 114 for defendants. And that, pursuant to State v. Wolf, recently decided case, is not appropriate during the preliminary.
Permit holder with purchaser.
Yes, yeah, would have to replace permit holder with purchaser. Broadly, Measure 114 addresses two issues. There's the magazine ban. That issue has been addressed by this court already. And then there's the overall permit to purchase scheme encompassing the permit to purchase, the completed background check provisions, as well as verification of the valid permit to purchase, and the gun registry. Those are all part of one scheme as sold to the Oregon state voters, as well as in the design of the statute itself.
I mean, when you say sold, what you really mean to say is based upon the legislative intent that's articulated in the voters pamphlet.
In the
right?
voters pamphlet,
Rather
yes, Your
than
Honor. Yes,
speaking with clarity under the law.
yes, Your Honor.
Got it. Go ahead, please.
The voter pamphlet, defendants have provided a different version of the voter pamphlet than was cited by plaintiffs, which does include reference to passing a background check to acquire a firearm. That's in the summary only, page 81 of the reference from defendants. However, this summary is unclear whether that requirement is separate from the completed background check required to acquire the permit to purchase. So that's misleading. Additionally, it's not addressed whatsoever in the result of a no vote, or I'm sorry, in the result of a yes vote in what defendants have cited, and is only referenced in the result of a no vote in what defendants have cited. In what plaintiffs have cited, there's no reference to it whatsoever.
So when you say page 81, you mean?
Of the Oregon voter pamphlet from Multnomah County, defendants have provided, have cited to, sorry, it is not an exhibit, it is cited to with a hyperlink in a footnote.
Okay.
So that provision, it does say must present permit, pass background check to acquire firearm. That's the only reference.
Do we have an agreement as to which voters pamphlet I'm supposed to be looking at with regards to these provisions? Am I looking at Multnomah's? Am I looking at Grant and Harney's? They're separate voter pamphlets for different districts, voter districts in Oregon. I guess I would like the parties to, because you make a page reference for me on 81 is not the same in my voters pamphlet. So I'd like to know what our agreement is, because we're going to have an agreement on that today. Mr. Wilson, what's your suggestion on which voters pamphlet the court should use?
Our understanding, Your Honor, is that the Measure 114, being a statewide measure, has the same ballot title as reprinted in every voter's pamphlet. And so the voter's pamphlet that we reference in our footnote is a perfectly acceptable one to look at, but any county has the same one.
They're the same pagination for each county?
No, they are not the same pagination.
If you're referencing a page number and it's a different pagination based on Harney or Multnomah, I'd like to know that we're all on the same page. So if you could tell me specifically which voters pamphlet I should be, I agree they all reflect each other and a copy of one another, but they have different paginations. So I'd like to know which one we're talking about. So when I go look to page 81, I'm not looking at the wrong page.
Your Honor, if I can simplify this, plaintiffs have no objection to, I did personally look at the Harney County voter pamphlet late last night. It's a different page. From the best of my memory, I believe it was page 61 in that voter pamphlet, but I'm going from memory there. But I don't disagree with Mr. Wilson that the language is the same. I did specifically look at the Harney County voter pamphlet to verify that. The version that plaintiffs have cited comes from the Oregon Secretary of State's website, and that language differs. So, that's what plaintiffs are addressing, and that language is different.
Okay. So can we agree on what I'm supposed to be using for reference for the remainder of this litigation?
Your Honor, we would ask that you use what is referenced in our footnote. That's as plaintiff's counsel correctly points out, is from the Secretary of State's website. That happens to be the Multnomah County voters pamphlet, which contains on page 81 the ballot title for Measure 114. And my understanding is, as plaintiff's counsel says, that ballot title would be the same in the Harney County pamphlet, but would have a different pagination.
And Your Honor, plaintiffs would ask that because the language differs between what was on the Secretary of State's website and what was printed in the Oregon voters pamphlet, that this court examine both.
All right. Go ahead.
Turning to the specifics of ballot measure 114, defendants assert that section 6.3c, 613 b, and 614 can be either separately enforced or severed. It appears from defendants' brief filed last night that they are not asserting a severability argument, which plaintiffs would agree that severability is inappropriate. But because the arguments are not completely, that they're not mutually exclusive, I guess there's some confusion from plaintiffs on what defendants are arguing. Plaintiffs understand that defendants are arguing separate enforcement, not severability. So looking at section 6.3c, the court would have to substitute the words permit holder for purchaser, or would have to strike the language permit holder from the language of 6.3c to allow defendants to enforce that provision. To the extent that defendants are asking the court to strike language, that would be inappropriate at this juncture. To the extent that defendants are arguing that they can separately enforce that, plaintiffs would say that the court would have to rewrite that section for them, substituting the language. Turning to 613b, that section concerns firearm dealer liability. There's no evidence in the voter pamphlet that the Oregon voters intended to allow a firearm dealer to transfer a firearm through what defendants characterize as a loophole, but impose liability. There's no talk, there's nothing in either voter pamphlet discussing the issue of liability or the idea that that could be severed or separately enforced. Additionally, section 6, subsection 14 makes it a crime to transfer a firearm without a completed background check. It would make no sense if pursuant to 6.3C, a firearm dealer could transfer the firearm, but it was also considered a crime. That doesn't make any sense. So plaintiffs assert that these provisions cannot be separately enforced from the permit to purchase provision. Turning to section 7, defendants point to section 7(3) little d big B and argue that it can be severed or separately enforced. That subsection says that a transfer cannot be completed unless the purchaser is qualified. Pursuant to the scheme proposed by Measure 114, one of the prerequisites for qualification is a valid permit to purchase. So the court would have to rewrite that provision to get rid of that prerequisite in order to determine that an Oregonian is qualified without a valid permit to purchase. Last, section 8, defendants cite to section 8(3)(c) and argue that it can be severed or separately enforced. That's the same analysis as section 6(3)(c), which was already discussed and would require the court to substitute permit holder for purchaser. It's obvious that the Oregon voters intended the completed background check provision to be a part of the permit to purchase provision. And so until the permit to purchase scheme is ready to go and can be constitutionally evaluated, it would be inappropriate to allow the separate enforcement of these provisions and have 37,000 plus Oregonians waiting to purchase firearms who cannot receive them. That would certainly be an infringement on their rights under Article 1, Section 27. It would be and would be violative of the standard addressed in Christian. Christian says that the state can regulate firearms.
But you agree that background checks are a part of our current statutory scheme and are a part of the statutory constitutional scheme throughout the country under the Second Amendment as well as under Article 1, Section 27.
Plaintiffs would agree that they have been upheld by courts frequently. However, plaintiffs would dispute that allowing indefinite periods for the process of background checks has been upheld.
It doesn't say that though. I mean, this doesn't on its face say they can hold those background checks open for indefinite periods. It doesn't identify a time frame in which it must be completed. You would agree?
It does not say that they can, it does not in the plain text say that the state can take as long as they would like. However, that's the effect, and that's what Oregonians are experiencing now.
Okay, well,
we've presented evidence.
I understand those arguments. I think those are an as applied challenge, which I'm not allowed to do under Christian. Christian specifically tells the court you cannot do it as applied. You have to look to see if the scheme itself is constitutional or unconstitutional, period.
So, Your Honor, if we look at, for instance, the declaration from Dr. Siegel, I can find the page for Your Honor, but even the state of Illinois requires that background checks be processed within 30 days. Because there is no time frame requirement, facially, this background check provision is unconstitutional. There's a reason why the Brady bill allows for the relief valve to go into effect after 3 days. It's to stop things like this. What Oregonians are experiencing now. That is the purpose of it. That is a design function of ORS 166.412. That is the function of it. Allowing partial enforcement of the permit to purchase scheme is facially unconstitutional. One, because the permit to purchase scheme cannot even be constitutionally examined because it doesn't exist. And two, because it would require the court to rewrite provisions.
No, I get that piece, right? That's separate and distinct. So I'm analyzing it from two perspectives. I'm thinking first about whether the concept of background checks are constitutional or not. The subset of that, according to your argument, is whether there has to be a specific time frame in which they're completed in order to make the provisions constitutional. That's one.
Yes, Your Honor.
And then the second question is whether or not the language of this portion of ballot measure 114 is so inextricably linked with the permit to purchase that the court cannot sever it and look at it distinctly. That's how I'm framing the argument in my mind.
Yes, Your Honor. With regard to the first portion of how you're framing the argument, justice delayed is justice denied. A right delayed is a right denied. This is infringement because the state they have the ability to slow walk background checks, to not do them whatsoever. There's not even a requirement that they complete the background check ever in ORS 166.412. That statute's saving grace, this prior to ballot measure 114, was the fact that a firearm dealer could transfer the firearm without a completed background check. Therefore, the state isn't infringing. It's the firearm dealer who won't transfer the firearm, and the firearm dealer is allowed to not transfer the firearm at the firearm dealer's discretion. There's a reason why this relief valve was baked into the Brady bill. It was to avoid Second Amendment infringement. And there's a reason why it's echoed in Oregon's law, which is to avoid infringement pursuant to Article 1, Section 27.
Okay. And I only reach that argument if I think that they could be severable to begin
Agreed.
with. All right, go ahead, Mr. Wilson.
Thank you, Your Honor. I will begin with the severability question. We are asking Your Honor to dissolve and to not continue its TRO that covers the background check portion of Measure 114. I'd like to start by reframing in the question before the court. We are here on an ORCP 79 motion for a temporary restraining order. ORCP 79 gives Your Honor the authority to restrain defendants from performing certain acts. We are not here for the court to enter a declaration about the validity or invalidity of any specific section of Measure 114. The court will, at the close of this hearing, I expect, determine whether defendants can or cannot perform acts, not declare the validity or invalidity of Measure 114 sections. With that framing in mind, I'd like to turn to what the court has already done.
Well, hold on. That's partially. I mean, that's true, except I still have to evaluate under Elkhorn the likelihood of success, which does get me to the question of whether there's validity, if there's a valid claim of unconstitutionality to the statute, right?
Defendants do agree with that, Your Honor.
All right, go ahead, please.
So, Your Honor, I'd like to then turn to what the orders the court has already enacted. The court presently has 3 orders in response to plaintiff's motion for a temporary restraining order. The first is the preliminary injunction enjoining large capacity magazines. The second is the temporary restraining order restraining defendants from enforcing the permit requirements of sections 1 through 10 of Measure 114. And the third is the temporary restraining order restraining defendants from enforcing the background check provisions of ballot Measure 114, sections 1 through 10. It is only that third order that we understand to be the reason we are here today. And it is only this third order that defendants are asking the court to not continue and to affirmatively dissolve.
So, Mr. Wilson,
So
to that end, the third order did not exist initially. There were 2 orders. The defendants requested that I take up this specific area as a third order, and then I continued the TRO on this area, separating it out to give you an opportunity to be heard as quickly as possible. The court's initial orders were a TRO on section 11 and then a TRO on sections 1 through 10. Right?
We understand, Your Honor. Yes, Your
Okay.
Honor.
I don't want you to, I don't want it to be framed like I'd made 3 separate orders initially. So I appreciate it. Go
No,
ahead, please.
Absolutely, Your Honor. I understand it. And I point this out only to frame the question that we are presently here before.
Right.
So then, Your Honor, the question becomes, is measure 114 able to be construed in such a way that it is severable? I'd like to start with the case law about when severability is appropriate. And a good statement of that is found in a case that plaintiffs cite, which is Advocates for Effective Regulation versus the City of Eugene, 176 ORAP 370. That case states, when an individual provision is severable from the enactment of which it is a part is a question of legislative intent. Then it goes on to say, in this case, the initiative contains an express, broadly worded severability clause, which provides that if any portion of the initiative is declared to be invalid, it is the intention of the voters that it be severed from the remainder. There is nothing ambiguous about the intentions of the voters regarding the issue of severability. Just like in Advocates for Effective Regulation versus City of Eugene, Your Honor, Measure 114 has a clear severability clause. And I'd like to read that clause because it has some language that defendants think is very important to Your Honor's analysis. Measure 114 severability clause states, if any provision of this 2022 Act or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of this Act, which can be given effect without the invalid provision or application. And to this end, the provisions of this Act are severable. And here's the important part, Your Honor. It goes on to say the people hereby declare that they would have adopted this chapter, notwithstanding the unconstitutionality, invalidity, and ineffectiveness of any one of its articles, sections, subsections, sentences, or clauses. Your Honor, what the people of the state of Oregon have asked is that any severability analysis, well, first of all, that a severability analysis must occur. And when it does occur, that the courts go down into such detail that they consider individual sentences and clauses if necessary. So with that instruction from the will of the voters in mind, I'd like to turn to the provisions of Measure 114 that address permits and the provisions of Measure 114.
Let's pause there for a moment. You use some operative language that's important. When
yes,
it occurs, and it's raised in the plaintiff's memorandum that when it occurs is after there's been a determination on the constitutionality of the entire statutory scheme. And if a portion of it is found to be unconstitutional, then the court can starts parsing between clauses and phrases and gets down into the minutia of eliminating the piece, redlining, I guess, the pieces that are unconstitutional. So there hasn't been that determination, as you pointed out earlier. So doesn't severability occur after the court makes a determination on the permit to purchase question?
I disagree with that analysis, Your Honor. If that were the case, a plaintiff could have an entire statute declared unconstitutional on a preliminary basis simply because a single small subsection of it had a constitutionality issue, and not even one that was determined on the merits. And so you could have an entire statutory scheme enjoined from enforcement simply because a small subsection may have a constitutionality problem. And so to take Measure 114, for example, if Your Honor if plaintiff's argument were correct, then plaintiffs could have just moved for a preliminary injunction against large capacity magazines ignored the rest of the measure and asked for a preliminary injunction that covers the entire measure. That cannot be what the law requires. Plaintiffs have a burden. It is their burden to show that enforcement of the measure in all of its particularities would cause them injury so severe that the court must enter the extraordinary remedy of preliminary relief pending outcome of this litigation. There is no case, and the case that plaintiffs cite does not deal with holding an entire statutory scheme under a preliminary injunction until one piece of it can be determined at the end of trial. There is no case that so holds. It is their burden to show that everything they want enjoined, they meet the burden to enjoin that, all those particular sections.
Okay. Go ahead, please.
Yes, Your Honor.
So, Your Honor,
Oh, sorry.
I interrupted him. I'll call on you in just a few moments. Go ahead.
thank you, Your Honor. I'd now like to Your Honor, to consider the sections of ballot measure 114. So I'm referring here now specifically to section 6. And if you look closely at the sections of ballot measure 114, there are some that apply to the permit requirement, and there are some that are amendments to Oregon's existing background check law. So to start with an example from the permit requirement, section 6.2a adds bold-faced language that states that a purchaser must have a valid permit issued under section 4 of this 2022 act. And section 6.2d requires the dealer to verify that the purchaser has a valid permit to purchase. We are not, at least here today, talking about either of these sections. These sections apply to the permit to purchase program only. They do not have anything to do with the background check amendments. In contrast, you can turn to section 6.3c. Section 6.3c has two provisions, and it states, the dealer may not transfer the firearm unless the dealer receives a unique approval number from the department, and within 48 hours of completing the transfer, the dealer shall notify the state that the transfer to the permit holder was completed. So first of all, Your Honor, I just want to point out, so there's no confusion, that a unique approval number from the department, that is already part of the statute. Oregon's existing law provides that the Oregon State Police should issue a unique approval number when a background check has been approved. There's nothing new about that. So then let's talk about what section 6.3c provides. It does not have anything, it does not in any way require a permit. It is correct, and as plaintiffs point out, that the second clause of that sentence refers to a permit holder instead of a purchaser. I have two things I'd say about that, Your Honor. First, the phrase permit holder is surplusage. It is perfectly reasonable for this court to read the second clause without the phrase to the permit holder. For example, within 48 hours of completing the transfer, the dealer shall notify the state that the transfer was completed. You do not need to include the to the permit holder language. But second, even if Your Honor is concerned that the second clause of section 6.3c refers to permits, Your Honor still may restrain just the second phrase and allow the state defendants to enforce the first phrase. And that would be consistent with Measure 114 severability clause, which asks the court to make a clause by clause and sentence by sentence determination of severability. So under that reading, the court would restrain defendants from requiring dealers to report within 48 hours of the completed transfer that the transfer to the permit holder had been completed, but it would not restrain the state from enforcing the provision that the dealer may not transfer the firearm unless the dealer receives a unique approval number. Now, Your Honor, I'd like to turn to section 7 6.3d(b), I'd like to address one of plaintiff's arguments here. This is the section that states that requires a dealer to receive notification that the transferee is prohibited by state or federal law from possessing or receiving the firearm, or that the department is unable to determine if the transferee is qualified or disqualified from completing the transfer. Plaintiffs are arguing that the phrase qualified or disqualified necessarily encompasses whether or not the individual has a permit. But that is not a good reading of the text of the statute that Measure 114 modifies. If you go back up to what subsection B is under, it's under subsection little d. So if you put it all together, allow me to read it. It says, if upon completion of a criminal background check, the gun dealer receives notification that the transferee is prohibited by state or federal law from possessing or receiving a firearm, or that the department is unable to determine if the transferee is qualified or disqualified from completing the transfer. This section is referring to the criminal background check. That's what little d says. It is not referring to any permit requirement, and it is referring to what the dealer receives in response to the criminal background check. It is not referring to what the dealer receives regarding the validity or invalidity of a permit. This section deals only with the Oregon's existing law on background checks. And there is no reason that the court need restrain it simply because the court has already entered a restraining order on the permit requirement.
So what, I mean, isn't the remedy for that though encompassed within, if there's an unable to be determined, isn't that remedy encompassed within the sections 1 through 10 through judicial review, which wouldn't exist until a determination is made on the final question of constitutionality?
I disagree with that, Your Honor. The sections for appeal review of permit determinations are separate. I believe you're referring, I think, Your Honor,
That's what I'm
to
referring
section 5.
to. Yeah, that's what I'm referring to. Okay.
Yes, Your Honor, we don't believe, that this refers to that.
So there just is no remedy to a gun purchaser if the department's unable to determine if the transferee is qualified or disqualified, then that's the way it is.
Well, that's all encompassed within existing law, Your Honor, and the existing law does. I do want to just briefly mention that plaintiffs have stated that there's no requirement that Oregon State Police reach determination, but I'd point, Your Honor, to ORS 166.412 3A, which does require the department to immediately process and determine from criminal records and other information available to it whether the purchaser is disqualified under ORS 166.470. So if the department failed to do that, they would have a remedy under the law.
Thank you. Go ahead, please.
Okay, so that takes us now to section 8C, Your Honor. And this is a section that again has the same permit holder language that is found in section 6.3C. My arguments here are the same as those that I had with respect to section 6.3C. First, that the permit holder language is surplusage that can simply not be included in the court's ultimate order on this issue on enforcement, or alternatively, the court has the power, the discretion to simply choose to enjoin the state from enforcing the second clause, but permit the state to enforce the first clause, which is exactly what ballot measure 114 severability clause asks this court and all courts to do. Briefly, Your Honor, I'd like to turn back just to the two remaining sections. These are under section 6, 13, and 14. These sections are easily parsed to allow the court to allow the court to enter an order that restrains the permit requirement, but not the background check amendments. In section 613 sub B, ballot measure 114 adds two provisions. The second of those provisions is that the dealer has received a unique approval number from the department indicating successful completion of the background check. It is perfectly possible for your honor to write an order that restrains the state from enforcing the first part of the additions to 13B and not the second part. The same goes for section 14. Section 14 makes it a crime, a class A misdemeanor, to knowingly selling or delivering a firearm to a purchaser or transferee in two instances: when the purchaser or transferee does not have a valid permit to purchase, or when the prior to receiving a unique approval number, the transfer happens. It is perfectly possible for your honor to restrain the state from enforcing the first clause, but not from enforcing the second clause. And that is in fact what we are asking your honor to do. All told, your honor, ballot measure 114 expressly and by the express language of the people who voted to pass it asks this court to engage in a thorough and detailed severability analysis. And it is under that analysis, down to clause and sentence, it is possible to sever the background check amendments from the permit requirements. Therefore, we'd ask your honor to do that and to find and to dissolve the TRO with respect to those sections and allow the state to enforce the background check amendments. If your honor would like, I'd also like to briefly address the facial challenge argument. If your honor does in fact find that these provisions are severable, the question then is, should your honor nonetheless continue a TRO or issue a preliminary injunction that enjoins the state from enforcing the background check amendments? And as your honor has already pointed out, we're not here today to consider that on an as applied challenge. So the only question is whether it is facially unconstitutional. I have two arguments with respect to that. The first is that there is simply nothing in plaintiff's pleadings which allow or which allege and assert that the background check amendments are standing alone unconstitutional. You read the paragraphs of the complaint that are in the claim for relief, the actual request to the court for relief, all of them address either the permit requirement or large capacity magazines. ORCP 79 only allows the issuance of a temporary restraining order in those instances in which it appears that a party is entitled to relief demanded in a pleading. It has not been demanded in plaintiff's pleading that the court enjoin on a facial basis the background check amendments. My second argument, your honor, is that there is no law, case law cited, and no known case law to defendants that holds that the background check amendments requiring OSP to issue an approval before a firearm can be transferred are facially unconstitutional. As I just read from the statute, the department must make a determination about the qualification of a person, and the fact that there is not an express time requirement does not make the statute facially unconstitutional, and no case so holds. We point out in our briefing, and I won't repeat it unnecessarily for the court, but I would refer the court to our briefing in which Oregon case law and Oregon appellate courts have held that the legislature and Oregonians have the authority to restrict who and who may not have access to a firearm. And that is exactly what ballot measure 114 does. It is constitutional under Article 1, Section 27. Thank you, Your Honor. We ask the court to dissolve any TRO with respect to the background check amendments.
Thank you. I mean, I gotta tell you, the last piece I just think is fundamentally just half of what the courts have said. And that's already in my other findings on Section 11, but it says that there has to be a cause upon which to restrain a person from having a firearm.
I don't disagree with that, Your Honor, but that is what ballot measure 114 is attempting to determine, is whether a person is in fact legally allowed to own a firearm.
Okay. Thank you. Ms. Wilson, go ahead, Mr.
Thank you, Your Honor.
Gallo.
I'd like to start backwards here a little bit with the facial challenge issue. In defendant's briefing, defendants cite to.
It's in there. It's in paragraphs 18 and 23. You raised it.
Yes, but also defendants invoke a First Amendment case upholding a 28-day permitting timeline for a permit to hold a rally. There's a timeline in that case, 28 days. Here, there is no timeline whatsoever. And I agree, there is no Oregon case law on point saying you cannot indefinitely delay people, because such a radical proposal has never been made. However, plaintiffs in their complaint, motion, and their response to defendant's objections cite to Bruin, footnote 9, which says that lengthy delays and excessive costs could cause a permitting scheme, and that's just for a permit to carry publicly, not to merely acquire a firearm. But such a long permitting process, lengthy, here indefinite. It's infinity. It can go on for as long as they would like, as long as the state would like. That is the standard that this statute puts into place. So whether we're looking at it in a First Amendment context, there has to be some kind of timeline, and there is no timeline.
Just hold on a minute.
Yeah.
I mean, what about ORS 166.412 subsection 3A, as pointed out by Mr. Wilson, that upon a request of the gun dealer for a criminal history record check, the department shall immediately, during the gun dealer's telephone call or return call, make the determinations.
That's just a determination about whether they are. So if Your Honor looks at Brian Jones' declaration, he talks about the way this procedure works. Karen Lejeune's declaration has similar language in it. It starts with a black check review. So if it can be determined right away that a person is approved, which is the minority of Oregonians, according to Declarant Lejeune, then yes, that's immediate. However, the majority of Oregonians, upward of 60+%, upward currently of 37,000, get delayed indefinitely. Mr. Callaway's declaration shows that there's one gentleman who attempted to purchase from his store that has been on hold since April 16th, 2020. That is not immediate. And so there is no recourse. There's nothing an Oregonian can do to get fixed to move along. There is no immediate. The Measure 114's taken any teeth out of that word immediately, because there is no recourse. The determination that must be determined immediately is whether they are approved, denied, or pending, delayed. That's what 166.412 says, that there must be a determination of pending. However,
I assume that the immediately is also informed by administrative rule. Is it not, or is it?
Not that plaintiffs are aware of, but it still only applies to that preliminary determination about whether an Oregonian falls into a immediately approved, immediately denied, or delayed. And there's evidence that presently Fix is delaying people 2+ years. That's not immediate. And so taking out any relief valve makes this provision unconstitutional, because there's nothing an Oregonian can do. Additionally, defendants are simultaneously saying they're not arguing a severability argument, and then pointing towards the severability clause. Plaintiffs would assert that the question is, can these provisions as written be separately enforced? And if so, was it the will of the Oregon voters? Plaintiffs say no. These provisions cannot be separately enforced. Looking at section 6, the court will have to strike out entire portions of that section, including the requirement that a purchaser obtain a permit to purchase before they can purchase a firearm. The court will have to strike that language out. Likewise, section 7(3)(a) defines who is qualified, which
I don't know about
includes
strike, sever the provision into two pieces and take the portion of the provision that refers to a permanent holder and set it aside. I don't think it's strike.
defendants are arguing a severability analysis, which would be striking provisions that are unconstitutional. Because those provisions have not been determined to be constitutional or unconstitutional, it's inappropriate at this time for the court to allow separate enforcement of that. And that language is present in section 6(3)(a) and 8(3)(a). Both require a valid permit to purchase in order to purchase a firearm. Thank you, Your Honor.
I appreciate it. Thank you. As I said before, I'll be taking it under advisement and making a determination by January 3rd on this limited question. Mr. Wilson, it's my understanding from reading the plaintiff's pleadings that the state is now indicating it won't be prepared to move forward with any permit to purchase program until at least March. I don't want to burden my docket with a bunch of status hearings. Is that accurate then?
We have, I think you're referring to the pleadings in the federal case, Your Honor. We have, it is correct, Your Honor, we have submitted a status report to the federal court in which we ask the federal court to continue an injunction over only the permit to purchase piece, not the background check amendments piece, but over that piece until March 7th. That we have requested that. The court has not entered that order yet, but we don't see any reason why it wouldn't.
Well, the question for this court is when to set another status hearing to determine or if I just leave it to you all to send me notice that you're prepared to move forward with the permit to purchase program and then initiate litigation at that point in time within the 10 days.
That's what we request, Your Honor.
Okay.
We would
That's
give
fine.
you that 10-day notice.
So I will continue the remainder of my temporary restraining order on the permit to purchase program indefinitely until notified by the defendants that they're prepared to deploy a permit to purchase program. I understand you object to the original TRO, but that's what I'm going to do.
Understood, Your Honor.
And I'm relying on the process that we just discussed in order to make that order. And that you will have a remedy of a 10-day hearing when you're ready to deploy the permit to purchase program. Well, thank you, gentlemen. It's a more esoteric hearing today. I will make a decision about how I see the question of severability here with regards to these portions and whether they can be decoupled from the larger permit to purchase program. And I'll have that decision to you by January 3rd, 5 o'clock. Is there anything further, Mr. Iola?
ILO, Your Honor.
ILO, I apologize.
It's okay,
With the last
Your Honor.
name Ratio, you would figure I would learn to say it correctly by now.
That's all right.
Say it again.
So how I explain it to people is it's ILO.
L-O.
Yeah.
Okay.
It's just
ILO.
extra letters
I
in
can
there.
figure that out. ILO. All right.
No, Your Honor. Thank you.
Be safe on your travels home. It's slippery.
Yes, Your Honor.
Mr. Wilson, anything further from the defendants today?
No, Your Honor. Thank you.
All right. Thank you. Hope you each enjoy an extended weekend, and we'll go off the record.
Merry Christmas.
Okay, so the court is over. They have put in a TRO, or left the TRO indefinite on the purchase to permit, or the permit to purchase, sorry, until the state can provide information that they are ready to proceed and that they have everything in order to go forth, and then the courts will schedule another hearing within 10 days of getting notice. So we will go live again to hear that part once we have information on that. And like you heard, the judge will have his determination on if any of the delaying will be considered constitutional or unconstitutional, and that ruling will be by January 3rd. If he stays true to the way he has been, I would suspect that we will have a ruling before January 3rd. It will be a short ruling because he hasn't been like putting out 30-page rulings. So again, we everything is status quo right now, so everything's still on hold. At least till January 3rd, we'll find out if he's going to sever or separate any parts of this, and we're hoping that he keeps it all enjoined and keeps his TRO in place. I do want to thank everyone who has spent a little over an hour listening to what the courts had to say. I know sometimes it gets a little boring listening to the way the attorneys argue everything, and it can be kind of confusing. So, again, at least this wasn't another 8-hour argument, but I kind of would have liked to have heard a little more arguing on this. Maybe bring in some witnesses and have some more testimony. So as I hear more and more about this, I will be scheduling more of these live streams. So Smeggy, the link is in Discord in GWeb's Discord, or sorry, Gilded page if you want to join. Yes, GGW. It is still unconstitutional to permit a right. And so, yeah, I honestly think that this judge is going to end up ruling in our favor. I can't wait for when the trial starts, and that will be a great listen. And so hopefully we get this going a lot quicker. It does sound like the courts just don't want to, schedule 36,000 hearings and be like, okay, well, we're going to waste 5 minutes of the time just to find out that you guys still aren't ready. So we are joined by Mr. Smeggy. Welcome,
Hey,
Smeggy.
how's it going?
It's going good. So, what's your thoughts on what you heard?
Give me a second.
So, yeah, and man, Canada, you guys really need to get rid of the Trudeau. Trudeau. Well, can't ever pronounce his name right. I think that's a French thing. Javi's Hobo says, we're playing the waiting game on new regulations in Canada right now as well. We have little hope of winning. Unfortunately, the Gov is going to take our guns. I don't know, because if, Trudeau gets his way, yes. But I've heard some rumblings that some of the other people in Parliament, even on the not so friendly side, are like kind of leaning towards not agreeing with him, because a lot of them are getting pressured from other countries, which is weird that other countries are weighing in on what's happening in Canada, and they're kind of weighing in on what's happening in the US, but not so much. So hopefully, you guys definitely get people to be like listening to, what's going on here and go, wait a minute, we don't want to deal with that kind of crap.
I mean, that's really like when people in different states care about Oregon, right? We want to know what's going on there because one, it might spread, and two, if we can help, then we want to help.
Absolutely, and if I hear of like court hearings that are going on in California that I can, stream like I'm doing with the Oregon cases, I'm going to do that, because it affects us all. If I hear stuff that's going on where I can stream it out of, New Jersey, New York, stuff like that, I don't have a problem doing that, because this is stuff that's going to affect every single person in the United States at some point. There's possibility of infringements everywhere.
Yeah, and the more infringements that are allowed, it's going to embolden other places, right? Like if only ever one state had a mag ban, all the other ones would be like, oh, well, we can't do that. But because there's 5 or 6, Oregon's like, well, I guess we can do it too. But look, the other guys are doing it. So the sooner we get that struck down, which I know it takes time, courts are always, a long, slow process. But hopefully this might be the catalyst that gets all the way up there. And then a loss in Oregon ends up affecting California, New York, Illinois, like all those other ones. So I actually have to jump into, gotta go to another store here real quick, but I'll stick on the line and be muted. I just wanted to give my thoughts on today's hearing. I'm glad we won. And other than that, I was so distracted. I was trying to listen, but a lot of it went past me. So that's my summary. That's my contribution. I'm sorry,
Yeah.
normally I was trying to keep along, but I got to get all this stuff for Christmas dinner. So it's not the best time to go to the grocery store 2 days before Christmas. It's kind of crazy here.
Hell
But
yeah.
anyways, I'm going to mute here for another few minutes. I'm going to run to this other store, get one more thing. And
Okay.
then If you're still on, I'll join you, and if not, then I'll just listen to your summary of what exactly happened.
Yeah,
And thanks for having me, and thanks for streaming.
You're welcome, and thanks for joining in. So, I know that right now we have the mag ban out of California that's in front of Benitez, and I believe he's going to be ruling on that here pretty soon. So, truly, if we can get that ruling, that will go in front of the 9th quicker than what's happening in Oregon or what happens in Washington, because that's already sitting, right there, ready to go. And so, if the courts do what they're supposed to do based on New York Rifle and Pistol v. Bruin, the mag ban in California will be struck down and ruled unconstitutional, which will then affect everybody on the West Coast under the 9th, and which will give
Hawaii.
Yep, Hawaii, Alaska, Washington, Oregon, California, Idaho, Utah. So yeah, it will be like end of February, I think, when all those cases are finally played out in front of Judge Benitez. I think it's end of January, beginning of February. I can't remember the exact dates that were given by Judge Benitez on everything that has to be in place and all that. Probably going to try to reach out to some of the organizations in California to find out if there are links to court dates that we can live stream and get that information out there for everybody also. But again, being able to listen in, and not everybody's going to understand all the legal mumbo jumbo that's being said, and I'm not going to say I'm going to be able to break it down to layman terms. Yes, I have been involved with the courts because as a kid I wasn't the greatest of kids, so I spent a lot of time in the courtroom. And so I do understand some of the legal jargon and stuff, so I can try to help and break it down. So like with today, the state's trying to throw all these, hey, we need to separate everything out so that they can more. The reason they want to separate is so that they can't they can't just have a blanket. Okay, this is going to encompass everything, and they're more likely going to lose on an entire, on a broad base. But if they can break it down so that there's 14 different situations, then they may win one or two of those, because the courts may say, well, that right there may not truly infringe too bad, so we'll let that go. But if it's done on a broad base, then they can't break down each individual cause or each individual section, and that's what the state wants to do. It's, hey, let's break this down to every single section so that we can get little bits and pieces of this, and then we can try to expand from there. And so I do really hope that he keeps it all enjoined as one big, because we're more apt to win it all um, if it does stay as one gigantic, because they've broken parts of it, which was the magazine portion of this. They got that separated. So we've got, everything dealing with the permit to purchase, and we've got what they allege the Charleston loophole, which, like the GOA attorney was explaining, is, hey, this has been in there on a federal base. This was put in there so that, the citizens, us, the individual person, can't be held indefinitely waiting on a response. So any firearm retailer, LGS, big box store, whatever, after 3 days has the legal right to turn over the firearm if they have not gotten the 4473 back. Now, we all know that the likelihood of 98% of them is that they're not going to, because if by chance the 4473 comes back 5 days later, 10 days later, whatever, and there's a delay or a deny, then they're responsible on getting that firearm back. They're responsible to notify, local law enforcement that, hey, this person has now been delayed or denied, and we need this firearm brought back to us. So that's a lot of the reason why the LGSs will not turn over a firearm after 3 days. And I think the firearms dealers, that will, because they're going and saying, you know what, the Constitution is way more important, and we're going to make sure that, people are able to protect themselves. So being able to turn over that firearm after 3 days, if they haven't heard anything back, is way better than like the guy that the GOA was talking about, who's been in, purgatory. He's been in just holding for 2 years. Talk about somebody who has been denied a right to protect themselves. They have been waiting for 2 years to get a response. I mean, holy hell. When it took 2-3 weeks to get my response back, I was thinking that was a hell of a long time. 2 fucking years. I mean, wow. I what do? Do you just write that off and be like, okay, and do you try to go buy a different firearm and wait to find out if you're going to be in, pending for another 2 years? I mean, what do you do? Do you initiate a lawsuit trying to challenge the fact that you've been denied your constitutional right? I mean, I know if it was me, I definitely would be trying to talk to some lawyers and seeing what could be done to force the issue. Yes, you could go and apply for a NICS ID, which is supposed to help you, um, get, like, because if your name is, John Smith or John Doe, whatever. There's going to be so many other people that have that same kind of name. And so if one of them people is a felon and your name is similar, you can be, waiting for them to figure out that it's not you that's, not supposed to have a firearm. So getting that NICS ID is supposed to help you. And I can't say if it does or if it doesn't. I haven't found that it helps any bit. And yeah, I lost my rights to own a firearm. It cost me almost $5,000 to get it back. Luckily, I have friends that are attorneys, and so it didn't cost me that much. There are people that are paying, close to $5-10 grand, and it could cost less. It all really depends on the situation, on how you lost your rights and everything. And if you lost your rights on a federal level, you're pretty SOL. I mean, only way you're going to get your rights back is with a presidential pardon. And the likelihood of that happening is unfortunately slim to none. So, reading some of the comments out in the side chat. Yeah, GGW is right. He says, as well as the AW, they're alleged, and I'm going to use air quotes, assault weapon, because we all know, ban the background check for ammo and magazine. So yeah, they have, I think, 3 or 4 different cases that are sitting at Benitez's desk that he's pushing back through as quick as possible to get back up to the 9th, because they've all been granted a writ of certiorari. So the Supreme Court says, yes, we'll hear this case, but we're sending it back down to the lower court so that they can re-rule based on our latest determination of New York Pistol and Rifle v. Bruin. So, something like that, Rob. Something like that. Welcome, 500 Mag. We're just kind of recapping what we heard in the courts earlier. They were only out for about an hour. So I don't know how much longer I'm going to keep this going, because I kind of want to keep it as short and compact for the court hearings. This way, we can get all the information out. And if people only want to hear what the court parts is, I got to go back in now that I have the computer out and
I timestamped it.
Yep. I got to do the timestamps for the original one and for today. Go put those in the descriptions so that it'll be easier for people to follow, and they can just jump along and only hear what's going on with the court.
You could timestamp as you go. You can re-edit your description, like as you're live. You can go into StreamYard and edit. I'm just saying, for future and for other people, if they try doing this thing, it's obviously much easier to go like, oh, that was important. Look up the time real quick, type it right in. You don't have to think about it ever again, rather than going back later. But anyways, today there wasn't much, like there's bunch of back and forth, and then just timestamp the judge ruling, which I think was 109 and 38 seconds or something like that. And then after that, they pretty much ended. So today's will be easy.
Yeah, today should be, pretty easy, and it theoretically won't take too long. The other one that had, 8 hours of court hearing, I'm just going to copy and paste the comments that you put out there on that video. I'll just copy that and paste it into the description of the video, which should timestamp everything in the video for people to
does that actually make like chapters or whatever? I've seen videos with that, but I never know like where it actually shows up at the bottom of the screen, not just a link in the description. Is that how you do it? Just put the timestamp in the description?
I'm not sure if it's just in the description or if you have to go in. I think you can just do it in the description. I'll talk a little bit more with GWebs, but yeah, going in and editing. If I just copy and paste those and go into the YouTube studio, I can probably post those in there, and it will, timestamp all that.
Because I know, like, if you timestamp in a comment, right? Like, you can do that on anyone's video. Anyone who can comment puts a timestamp in, and then it doesn't do anything to the actual video. But if someone's watching, they just click on that time, and it like links it to that video at that exact time. Like, so if people wanted to look at my comment, they could jump through. But I've seen other videos where, like, on the bottom, you'll see little white lines, and it's like, oh, this is chapter 1, intro, chapter 2, like opening for defense, chapter 3, and I've always wondered how to make those. So when you figure that out, I'd be interested to know. But it'd be cool if it's just pasted in the description and YouTube makes it itself, or if you have to do a separate step of like create chapter and then name it and put the time in and all that stuff.
I think once you open it in the YouTube studio, you can go in and say like add chapters, and then you can, like, if you have timestamps, you can just input that in there, and they'll go through and do all that, and then you might be able to like name them if you want to or not. Not completely sure on that. So yeah, I definitely want to get with people that are used to doing that kind of stuff so that I can make sure I'm doing it correctly. And maybe I can get GWebs or, somebody like that to do maybe an off-air tutorial for us so we can learn that kind of stuff.
Oh, I see. You want to hog all the information. Do it off air, so only you know. It's a little secret.
No.
I see how you
are. We can do it on air. I wouldn't really care.
Just tease it.
But, I know sometimes we have to do stuff off air just because that's when we all can, get together and, meet up. So, that's the only reason why I was kind of saying off air. But yeah, I still share all that information and everything because I want to, get as much information out to help people create a great channel, and help boost other people's channels. So yeah.
Yeah, I think that really helps for something like this. I mean, today's not the best example, so let's go with like the last hearing, that 8 hour plus. We all know that kills your watch time percentage on a channel, right? Like if you're normally making 2-minute videos and all of a sudden you have an 8-minute video, every person that comes in for 10 seconds and leaves, YouTube looks at that and says, oh, this video must suck because like people only watch 10 seconds of it. And so that's not good. But if you have chapters and all that stuff, minutes, and then I might as well stick around the rest of it. How would people just be like, you jump in, you click around a couple times, both times you click, it's something stupid, and you're like, oh, this whole thing is stupid, I don't want to listen to it. That's just how people think. So I think that's very valuable, and I do encourage other people to do similar things to what you did, because it is useful. And this guy does not know how to turn left. I'll just hit him, that's cool, whatever. Yeah, accident avoided. And anyway, so I encourage other people to do the same thing, and if we can help them with the timestamp and get good watch numbers, then that's good.
Yeah, absolutely. And for First Lady out there, today was actually a really quick one. It was a little over an hour in total time from when they went from the court starting to the court ending. There was just a very short hearing. Like I said before, I would have liked to have had it go a little longer. Unfortunately, it didn't. So I definitely will go through and put chapters in so people can, like fast forward through the video and hear the parts that they want and don't have to, hear me rambling if they don't want to. So the decision is that the TRO is going to stay in place indefinitely on the permit to purchase, at least until March 7th. And if the state can prove that they're ready to proceed with the permit to purchase, like they have everything in order, it's all funded, it's all, they have it completely ready, they can then notify the court that they're ready to go and schedule a hearing. And the judge will schedule that hearing within 10 days. And then they'll start arguing that portion of the case. So at this point in time, it's like status quo, and the judge should have his ruling on or before January 3rd. And if it's like last court case on the 13th, he didn't take long to get his ruling out. He said he'd have it by 5 p.m. on Friday and the 16th, and he had it out on the day before. So he was 24 hours ahead of when he had his deadline for his ruling. So, yeah, we will see what truly happens. And anything that I hear on this, either I will notify in a live stream or something like that, or like I did last time, as soon as I had confirmation of the judge's ruling, I copied and posted that ruling over on my community tab. So you can always check on my community tab to get him updates on what's going on with this case, and any case that I can get information on. So I want to thank everyone for spending about 2 hours with us today. And I'm going to play the outro and we'll get out of here. Anyone wants to come on and chat afterwards, I can always post a link or email it to you.